Okay, it's 2:29, so as agreed, we'll start. I like to be precise, to contradict stereotypes about Italians. Okay, we'll start now, and we'll have a coffee break, or should I say our much often mentioned cup of tea at 4:15. And so the first two speakers will make the presentations. We'll have a short debate, and then we'll go on with the last two presentations. Just a few words. We've seen this morning that in a number of South and Southeast Asian countries, Sharia is the personal law system for Muslim minorities. And although the regulation of internal diversity takes different shapes, as Professor Ferrari was mentioning in his speech. And it would be interesting to compare, for example, the case of India with that of, for example, Lebanon, which recognizes several religious communities that have their own courts and their own normative system, and which regulate their personal status with no or little government oversight, at least as far as I know. And then the case of Turkey, that I don't think was mentioned this morning, a majority Muslim country that has a formally secular country, and that has sort of ejected the Sharia from its law already in the 1920s. But as it happens with Europe, is often compelled or decides to take into consideration and even validate and recognize acts, religious or customary acts that are, let's say, not officially recognized by the legislation. Now we'll turn to Europe and Israel. And well, Europe, as you heard this morning, as you already know, is traversed by opposite trends. I mean, it's increasingly diversified due to immigration, and therefore it's increasingly traversed by transjurisdictional activities and the phenomenon of legal navigation. But at the same time, it's still mostly anchored to legal monism, and many states have an established church, which is recognized as special status, special, particularly in the financial field and in the schooling field. Europe is increasingly a secular country, and yet it is rediscovering, or many scholars would say, reinventing religions. And this, again, should make us wonder about the issue of religions, whether the concept itself of religion is not being reinvented under Western influence. Of course, it's difficult to talk about the West or even Europe, because Europe has many different societies, histories, legal systems, and policies, and this heterogeneity translates into different approaches to legal pluralism, different approaches which are reflected at the EU level in terms of adjudication, as Professor Ventura will explain to us. This morning we heard that the relation of religion and law has generated lively debates, which are quite renowned. How to reconcile religious freedoms with other rights, group rights, individual rights, how to reconcile in particular gender equality and religious freedom. And I think these debates are increasingly raising a number of conceptual and terminological issues, pointing to the need to rethink the underpinnings of our legal system. And to this end, I think that a multidisciplinary approach would be very much needed. And this not only when it comes to personal status law, but also in the criminal field. For example, the concept of cultural defense, which is also used in Italy by judges, I've recently learned, had resulted also in Italy in mitigated sentences. And in so doing, many would argue judges, Italian judges themselves, have reflected sort of anachronistic concept of culture as something static and irrational in a way, emotional and monolithic. So we should all maybe at the end of today or tomorrow, I think, debate also about these not strictly legal issues. Well, Britain is a particular case because I think it's the country where the emergence of an official fora and the prospect of validating or recognizing Islamic law has generated, stirred up most controversies, if I'm not mistaken. And most controversies and debates have focused on Muslim minorities, and little has been said, for example, on Hindu minorities. And in particular about how, about the relationship between Hindus and state law in the UK, particularly when it comes to caste discrimination, which has been the object of the Equality Act in 2010. The first paper by Prakash Shah will be exactly on this sort of unusual subject, but in this paper, from what I understand, some of his recurring themes will come out, such as the influence of Christian, in this case Protestant roots, in influencing the idea of law and the idea of religion and the idea of religious freedom, but he will explain in much more detail. Prakash Shah is well known. He's a reader in cultural law at the University of London, where he directs the Center for Cultural Law. He has published extensively and lectured internationally. He is the founder, I believe, certainly he manages Pluralism, which is a well-known list to which most of us subscribe, and which is the source of many interesting debates and information, and he's taken part in Rediger, which is a EU-funded project on religious diversity and secular models in Europe. So I'll give him the floor. Thank you. Yes, sorry.
I'll just move here. Perhaps I'll do what Andrew did, which is simply to stand, so at least most of you can see me. Thanks a lot, Elisa, for that nice introduction. And yeah, as you hinted, I think I'll approach the broader title, I think, with which we're briefed in a slightly unusual or perhaps unexpected way. But then those of you who know me also know that I'm no stranger to controversy, so that's probably in keeping with what you know about me. And as you said, instead of Islam, I will address a case study which is connected to Hindus, and in some way, I hope to be able to address the broader concern about protection of and from religion-based personal laws, but as you said, in an unexpected way. So let's start with reference to some of the assumptions which the workshop questions make and the description of the workshop makes. And in particular, I wanted to highlight this reference to stronger cultural and religious minorities. Now, of course, that is a kind of code, right? I'm not sure what good analogy might be, but it certainly gives this impression that there are some communities which are better at preserving or somehow attempting to institutionalize a religion-based personal law system, and then the question is what the extent to which or whether or not the state legal system should recognize them and giving them some kind of official status. And as we know from the morning's presentations, there are many examples also in the Asian jurisdictions which have that kind of question marks and also that kind of official character. Now, what is this code for? If you go deeper, I read it as a code for Islam, right? And that comes the entry point to my being controversial, because I wanted to deviate away from that, right? Partly also because I've given a lot of presentations on Islamic Sharia and the status in the United Kingdom, and it's getting a little bit dreary and boring. And there's a lot of stuff around there, around which you can read, right? Like there are so many book chapters and articles and even whole books now, yeah, on the subject. So it's getting a bit tired. Although I'm personally shocked. I mentioned the former Archbishop of Canterbury, Dr. Rowan Williams. In a way, he did us a favor by highlighting this subject, so many of us could become, famous in this particular domain. But it's also we have to sort of not thank him so openly, because it is getting a little bit tired now. The kind of sustained focus that this particular topic has attracted. I am, however, interested in the kind of presuppositional level in terms of why it is that the Muslim question has attracted so much interest, whereas relatively speaking, and in fact even absolutely speaking, the status of so many other minority groups in Europe has simply been neglected. I mean, the Chinese were mentioned this morning. Where is the research on legal pluralism in Chinese in Europe? Italy is full of Chinese people, but who's researching them, right? Virtually nobody, as far as I know. I mean, I'm sure there are professors in Italy who are interested in that subject, but that kind of stuff is hardly highlighted, and nobody's really interested. You don't get invited to conferences to speak about Chinese minorities in Europe, yeah? But if it's a Muslim thing, you can sell it quite well, right? So there's some kind of new type of political economy of knowledge which has been developing over the last let's say, 15 odd years, which I think tells us more than simply the substantive information that is imparted, right? I mean, one reason why legal pluralism claims are so strongly connected to Islam is, of course, no other group makes the kind of claims which Muslims are very often not necessarily claiming, but alleged to have claimed, right? In terms of their recognitional claims and so on. But certainly they are on the radar, right, as requiring a response within the legal pluralism framework. And our conference aims and description speaks to that kind of agenda very nicely. As a response and as an attempt to falsify my contention, of course, you can raise the question of Jewish law. But even the question of Jewish law, I mean, in the morning, I think, was it Andrew, you read something about the, one of these, the French Republican statement about the Jews being a nation within a nation. And it's quite interesting, actually, over a period of time. France is probably a more dramatic example of that, how Jews in the pre-revolutionary period were perceived as a nation within a nation. That's true. Right, with their own legal status, with their own personal laws, and so on. But with the, after Napoleonic France, gradually their status actually eroded. Yeah, and they were, rather than being treated as a separate religious community, they were simply treated as citizens. And Jewish communities themselves bought into that agenda. Right? They said that we want to participate in the abandonment of our personal law claims. And so France being a more dramatic example, similar type of thing has also happened in Britain. Right? Jews had their personal laws in England as well. Right? I think Silvio Ferrari sort of hinted at that in the morning, referring to many different types of communities or differently constituted communities in the European legal history which have their own separately recognized kind of status or ways of doing things. Jews were one of those communities, but also Jewish law was slowly phased out, if rather imperceptibly, in the English context, as you know, English like to do things in a more subtle way, right? They don't make big constitutional statements, but they will achieve what they want to achieve willy-nilly in some way, right? In some subtle way. And so Jews were basically, they had to reconcile to the fact that their separate divorce, marriage laws and so on would be recognized. And today, of course, you have a very minimalistic recognition of Jews in English law. I wouldn't call it a personal law system, actually. So is Jewish law an appropriate sort of invocation as a way of falsifying my hypothesis that the reference to stronger cultural and religious minority is a coded reference to Muslims? I don't think so. The fact that Jewish unofficial tribunals today are being researched is a function of the interest in Islamic tribunals, not the other way around, right? It's not that Jews have already constituted a case study over the last 20 or so years, and Islam is simply tacked on to that. It's the other way around, right? So the new research which is happening on Jewish rabbinical tribunals is parasitic on our interest on Islamic tribunals. So, this is also more about the conference aims and description. Legal pluralism. So our starting point is, of course, legal pluralism. You can see the title of the various presentations and so on. Legal pluralism features quite strongly. And it is true that Muslims are certainly seen as claiming, demanding, or favoring a system of Sharia law. And that was very dramatically recently illustrated in a survey that was done on which a documentary was based, which was screened by Channel 4. And our former head of the Equality and Human Rights Commission, Trevor Phillips, actually, he was the main sort of starring element. People refer to him as an equalities chief. I don't know if he was a non-black person or a white person. I don't know if he would be referred to as chief so often, but anyway, he's a chief, right? He's an equalities chief. And much was made out of that. And part of the emphasis of the documentary makers and the poll behind that was that such and such a percentage of Muslims that were researched favor a system of Sharia law. Right? So even when Muslims may not be demanding it, they are kind of provoked to demand it, right? By asking certain types of questions, right? Don't you favor us? No, are you not in favor of polygamy? What would you do? Do you support other people being engaged in polygamy, even if you yourself wouldn't support it, and so on? So directly or indirectly, they're associated with claims about Sharia law. In my view, apart from this sort of demand which was present in the 1970s among Muslims that a separate system of personal law should be recognized by the state in Britain, that demand has completely been phased out, as far as I'm aware, by the 1980s, when you actually did see the emergence of the unofficial Sharia tribunals. And since that time, I don't see the ulama in Britain really demanding a system of Sharia law. certainly not as a personal law system, right? In fact, there are many reasons to think that they will not demand such a system. I don't know, I mean, Rajnara, you've done research on this question, yeah? In my experience, when you talk to these guys, they actually don't want state interference in what they do, as far as I can see, right? So who is claiming this kind of thing? And who is asking the question whether or not the state should recognize the effects of such... so anyway, but those are sort of subsidiary questions which we can have an interesting discussion about later on. Of course, there is something, yeah? It's not as if such arguments and claims come out of nothing, right? There is this consciousness that being a religion of law, yeah? Islam is self-consciously identified by Muslims themselves as being a religion of law. In interaction with liberalism, such questions always tend to come to the fore, right? Because in a sense, Islamic legality can be seen as an antithesis to liberal legality, right? In ways that you will not see Muslims themselves claiming, but it's projected or framed in that particular way as an antithesis to liberalism. And Muslims are in a sense seen as a kind of prototypical example today of that way of organizing one's legal universe. Legal pluralism is raised as a framework that helps to respond to such a phenomenon, yeah, to the extent that there's a kind of reality about that phenomenon, or even if it's not real, if it's simply a projection. Legal pluralism is seen as a kind of appropriate aim, and at least a way of conceptualizing the problem, and possibly as something which is offering, right, a solution to the situation of communities such as Muslims. Now, on the other hand, if you look at the writings on Hindus, who also constitute, let's say, a quite significant minority population on the British scene, and increasingly in different European countries as well, there is some writing. I mean, Vernamensky, of course, has done writing on UK Hindus and legal pluralism, right? But at the same time, you don't really see claims or demands, yeah, in the way that Muslims are making about recognition of Sharia law and so on. You don't have this kind of palpable visibility of dispute resolution fora in the way that Muslims have created, or even Jews have, right? In fact, Jews have continued for hundreds of years in the British context. So it seems like a community like Hindus are presenting quite a different type of socio-legal reality compared to Muslims. Oh yeah, we heard about the Hindutva and so on. I can't see Francesco right now, right? You're here somewhere? Yeah, hi. Yeah, you're talking about Hindutva and so on. But look, even in the Indian context, yeah, the Uniform Civil Code is, of course, invoked. It's in the manifesto of the BJP ruling government at the moment and so on. But it's not advertised. You have read Hindu law into it, right? You say it's some kind of going to be some Hindu-dominated legal code and so on. Actually, we have no evidence of that because there is no draft, right? Point me to a draft of a Uniform Civil Code with all these Hindutva elements. How are they going to achieve that kind of thing? It's impossible, I think, right? Actually, even if it were conceivable, I don't think really it's possible to do that kind of thing with Hindu law, right? It doesn't lend itself to a code-like system at all, in my view, right? And so, good luck to them if that's what they think they're doing. I don't think I think that's a misrepresentation of the Hindutva project, but that's we can talk about that later on. So even the so-called Hindu nationalist BJP government is not claiming a kind of supremacy of its personal law that would, override all other personal laws and dominate, Muslims and Christians and so on, other minorities in India. So actually the Indian case also kind of speaks to this idea that Hindus are not displaying the kind of Semitic foundation-based kind of legal order that Muslims do. Yeah, so actually the last bullet point simply references that. Yeah? So Hindus follow a non-Semitic tradition, which in my view is not a religion. We can talk about that. We didn't discuss that hardly at all in the morning. Yeah, and perhaps we don't want to go there. It's fine if we don't want to. But certainly Hinduism doesn't represent, or Hindus don't represent any foundational truth claims in the way in which Jews, Muslims, and Christians might. So, yeah, here's my big claim about legal pluralism. In this context, it will confuse the issue, right? And you'll see later on why I'm saying that, right? It won't really provide, a real insight into the status of Hindus in particular, and into the kind of problem that's being tackled. if we look at some of the titles in 7 of the presentations for the in the conference description, we have the broad title Constitutional Protection of and from Religion-Based Personal Law. That suggests that there is a separation, the separation of the freedom of religion and freedom from religion. Right? There are 2 conceptually distinct entities, at least conceptually or intellectually. We can distinguish them. My contention is actually, no, they are part of a single move in Western cultural history. Right? And that's part of the thing I want to use in order then to illustrate or use the caste law example in the United Kingdom as an illustration of how it is that we can speak about those two ostensibly separate moves in a single move. Yeah? It's only by looking at them as part of a single move that we can even begin to make sense of what the caste law is there for. Yeah? Or why it comes about as a caste law, caste discrimination law. My claim is that in order to make them intelligible as part of single move, we have to reference to Reformation, Protestant theology. That's the source, right? That's how we can make intelligible the idea both of freedom of religion and freedom from religion, and why it's part of a single kind of conceptual framework. It's the Protestant theology that provides the conditions for intelligibility that enable us to make sense of both ideas at once. With the important caveat that they've both been secularized. Right? In today's terminological framework or conceptual framework, they've both been secular. Although originally stemming from Protestant theological framework, they've become secularized. Right? So they don't appear visibly as religious ideas. And there are other consequences as well, which we'll talk about. So to provide some kind of meat on the skeleton, if that's an appropriate metaphor, we have to look to the dimension of Christian freedom, or the elaboration of Christian freedom, and how freedom of religion becomes a core value in Protestant theology, while simultaneously articulating the requirement of freedom from religion. But it's not freedom from religion at large, it's freedom from false religion. Right? So it's only by reading into the idea of freedom from religion, an implicit claim of falsity of religion, that you get both can be made to work together, as they do in Protestant theology. So if we look at the example of Catholics and Jews, they've both at various points been assigned the role of those who follow false religions, and today Muslims are playing that role. Why is it that it's those types of traditions or religions which are cast into that kind of framework, or that role? Yeah, what is it about those religions that underwrites their falsity? Well, it was argued by Protestants that they impose a set of man-made laws, right, that prevent true, i.e. Christian, freedom of religion from being realized, right? So in a sense, this idea of this antithesis of liberal secularism that we see today, that move was already made within Protestant theology, right? And Protestant theology basically cast Catholics, Jews, today's Muslims as the antithesis of religions that do not observe freedom of religion, and what is required is a freedom from those religions in order to realize freedom of religion. Right? That's how the single move is made. And of course the objection would be that, those man-made laws, while being obligatory, they bind the conscience and interfere in the process of true worship. Right? So the Protestants were, of course, quite interested in having a method of worship in which there was no intercessionary kind of power or interference. Now we have to look at the secularization of those Protestant theological claims and the framework which gives life to them. So the idea is secularized by reconfiguring these Protestant theological tropes, and I'm using Jacob de Roover's new book on India, on secularism in Europe and India, and he's the one who sort of elaborates, if you like, a particular theorization of secularization and how it functions. So this would be, it's quite a different thing from the way in which people like Jose Casanova or Charles Taylor describe the process of secularization. He has his own particular theoretical take on how secularization occurs. And so ideas like the freedom of religion, conscience, the split between the private religious domain and the domain of the public secular, how that division become secularized and are retained as a topoi of liberal secularism. Right? So today, if you look at liberal theorists like, for example, Isaiah Berlin, he talks quite extensively about freedom from as well. Right? So in that kind of theoretical framework, you see that there is a kind of secularization of claims which are originally stemming from Protestant theology. Also, I mean, I want to put the idea quite strongly. Secularization does not merely involve a kind of copycatting of tropes, yeah, and topoi which derive from Protestant theology. It's more than that. It's not simply a question of origins of ideas, right? It's not, neither is it a claim about mere influence of different ideas, right? There is a relationship of dependency between the secularized ideas such as freedom of religion, conscience that we use today, and the original ideas of Christian freedom as elaborated by Protestants, right? So they are. It's quite important to sort of underline that relationship of dependency. What that means today is that although that Protestant framework has moved into the background, those ideas are not intelligible without having that Protestant background, right? So today we use these ideas in a rather loose way, yeah? You can see in the title of various of the conference presentations, they are ostensibly split, but actually they work together. They don't make sense without one another, right? So the way in which Isaiah Berlin begins to talk about freedom from, without reference to freedom of, it actually doesn't make sense, right? So the kind of criteria which are needed to evaluate what freedom from would even mean, right? It's not easy to kind of pin them down. In a similar way, when we're talking about the essential practices which are essential to religions or central to religions this morning, you see that in the Asian context, they simply break down, right? In a similar way, actually, Europe is also experiencing that problem today. Upon secularization, we no longer have the capacity or the ability to consistently use ideas like freedom from and freedom of, right? And when we do, we use them in a loose way, which begins to kind of break down. And so that's happening. And increasingly with the presence of non-Western minority groups in the European context, this is increasingly happening. So, yeah. Yeah, I mean, my further claim is that they actually, rather than solving religious conflicts today, they give rise to further conflict. Yes, secularism itself gives rise to further conflict, which might sound like contradictory aim, but contradictory outcome, but we can discuss why that would be later on if there's time. Yeah. So now I want to focus on India and its caste system and how that becomes a kind of also a manifestation or a result of these kinds of tropes being put into action. Right. So Christian theology held that religion was once revealed to all mankind, and accordingly, religion was strangely also found in India. It was always a promise and a presupposition of Christian theology, right? It was a core Christian theological claim that revelation was once given to all groups of mankind. Yeah? So when Europeans went to India and to other parts of the world, they didn't empirically find religion there, right? They expected to find, they already expected to find religion and actually happened to find it, right? So they identified something that they already expected to find. It's not an empirical claim of European social science that religion is a universal phenomenon, i.e. there's a religion which is specific to all cultures in the world. It's not like that. Yeah? It's a presupposition of their, which is given life by Christian theological claims. In fact, not just Protestant. Yeah? As the claim goes right the way back to St. Augustine. Anyway, so when you see Catholic missionaries, right, going to India, they elaborate their own kind of description of the Indian reality. Yeah? So they say Brahmins in India prevent their followers from converting to Christianity, and that's one of the reasons they thought they were evil priests who keep people languishing in false religion and idolatry. Right? That was a claim that could consistently be made within the framework of Catholic theology. No problem. Protestants came along and added their own insights into this kind of framework that the Catholics had originally elaborated. Right? What they say is that, yes, we'll accept that the Brahmins are the priests of the Indian religion. Right? That religion is Hinduism, and it also gives rise to a social system of caste, right? Which is legally sanctioned by those priests. Right? It's not only sanctioned, it's actually kind of enforced, right? They supervise this oppressive system of hierarchical order. And because it's religiously sanctioned, yeah, it is imbued with a kind of within a moral framework, and since that moral framework derives from a false religion, of course it has to be, by definition, immoral from our perspective. And so begins the story of the caste system, right, in India. It's actually an outcome, 100% an outcome of Protestant theological reflections about Indian culture and society. And there are some subsidiary claims like the Aryan invasion theory and so on, right? We can go into that later on if there's time during discussion. But the important point to note is that it's a system of social hierarchy which obliges Indians to act immorally, right? Because it's framed within a religion, right? And a false religion at that. It obliges Indians to act immorally and in a systematic way. They're continuously compelled to act immorally because of this kind of system, this religious system. Now, further claim is that eventually there's a kind of secular theorizing of the caste system, right? So the Protestant accounts are basically secularized. They enter Orientalist account, and eventually they give rise to the social science accounts about India and its caste system that we know today. Right? And they all presuppose as factual the earlier descriptions of the caste system that the Protestant missionaries were elaborating. So we fast forward to caste law in Britain today, and it's been claimed over the last few years that that caste system, immoral, which is of course by definition immoral, has been transplanted to the Indian diaspora in the UK. And the British Parliament in 2010, in the Equality Act of 2010, enacted a law on caste discrimination. So what it did was to add a clause to the Equality Act, which initially the clause was meant to give a power to a particular minister to make caste an aspect of race for the purposes of the Equality Act. Right? So you become a part and parcel of the definition of racial discrimination or the ground of racial discrimination. In 2013, that power was made mandatory. So basically, the wording shifted from the minister may to the minister must. Yeah? It made it obligatory. So now we're in this kind of weird position where the caste law has not been effected, right? There's no statutory instrument to give life to it, yeah, to implement it. But at the same time, the law does oblige the government to implement. The Equality Act does oblige the minister to implement that provision, right? So we're in this kind of status of limbo. And part of the reason it hasn't been enacted is because I, together with a group of Indian organizations, have been, for the last about 3 years, opposing it. So I'm rather politically incorrect, right? Because most right-thinking people would, of course, be in favor of a law against caste discrimination. But only if you go by the trajectory, yeah, of the kind of genealogy of caste and the system of caste that I described. Because everything that we know about the caste system actually presupposes that background, right? Without that, it doesn't really make sense. So how do we make sense of it in light of our claims about freedom of religion? So we can see that the tropes of the Christian freedom of religion now appear in secularized form, right? The caste system is a system against which we must fight, yeah, and against which freedom is to be secured. So freedom from a false religion, right, is to be secured by legislation. So we have various claims by parliamentarians which were made during the passage of the law, both in 2010 and its reinforcement in 2013. So Lord Leicester, who is a famous human rights lawyer, and in fact he's one of the brains behind the original Race Relations Act of 1976. He says that, no problem, yeah? Research is not required, yeah? We already know that there is a system of caste discrimination, yeah? Why do we need research to establish that such a system has now been transplanted to the UK with the Indian diaspora? One of the opposition MPs at the time, I think now, yeah, she was in 2013, she was an opposition spokesperson for Equalities, Kate Green. She says a single case of caste discrimination would be enough to act, right? Now, if you look at the provision on religion, which was brought about by pressure from various Muslim organizations, right? Muslims could not just say, you know, we have a single case of discrimination, you must put religion in the Equalities Act. They had to sponsor study after study. Yeah, there were various official studies as well to make sure that whatever foundation was there for claims about discrimination on grounds of religion, particularly against Muslims, was solid enough. But here you see a minister, right? So it's actually the way in which this legislation is passed, this provision in the legislation is passed, is quite exceptional for equality law, right? That people either say there's no research, it's obvious, even a single case would be enough to, for us to enact. So certain is that our knowledge about the Indian traditions, and the caste system, that it's become part of the common sense of European culture about Indian culture. Right? That Indians do systematically, after all, discriminate on grounds of caste. We know that, we don't need research. So that's a kind of thinking that goes behind the legislation. Now, also, if you look at the, Dalits, I don't know, some of you will be aware, we have some India experts among us. Those of you who are not India experts, you'll be aware that Dalit is a kind of political term or category, which is, in terms of the Indian legislation, is often translated as equating to scheduled castes or scheduled tribes, which was, basically groups of people, groups of jatis which are listed in the Indian legislation, the quota legislation or reservations legislation in India. So that terminology is now also infiltrating. That terminology about caste politics is infiltrating from India into the UK. So our various parliamentary figures cite figures of Dalits up to 500,000 by Lord Harris, who is an former Anglican Bishop of Oxford. By Jeremy Corbyn, who is the leader of the opposition party in the UK today, who also was in the all-parliamentary group on Dalits. He was the chair. He cited in 2014 a figure of 1 million, right? So we have also this sort of inflation going on in terms of the numbers of people we think are ostensibly being affected by caste discrimination. And the parliamentarians, of course, always presuppose that it's the lower castes who are, so-called lower castes, who are the targets of discrimination. So when Dalit activists make statements about, how the evil Brahmins and so on, which are quite consistent with the Protestant theological reflections about Indian culture and society, they are never taken to task. Nobody says you are making a statement which is discriminatory against Brahmins and so on, right? Because if you look at the framework of the race relations, a white person can equally sue a black person and vice versa, right? There's no bar on, the Race Relations Act doesn't say only white people discriminate against black people. The reverse could equally be the case. And there have been cases by white people brought against white people, right? So Scots can sue English, or English can sue Scots, and so on. That's actually happened. There are reported cases about that. But in this case, you see how the legislation also imports a presupposition about who is doing the discriminating, which is completely dependent on the earlier history of Protestantism, which we've talked about. One of the MPs who I have evidence of in the form of an email, about 3 years ago, wrote to a kind of whole, as part of a whole email chain. He was I don't know if he's still an MP, John Ashworth, maybe he is, right? Of Leicester, in one of the Leicester constituencies, and he says, I've never seen any evidence of caste discrimination in Leicester. Now, why is that significant? Because actually Leicester has something like 6 times, compared to the national average of the South Asian population in the UK, Leicester has about 6 times that population concentration. And he says, I've never seen evidence of caste discrimination in Leicester. So what do you make out of these claims? It'd be interesting. What is caste or the caste system? There's a kind of lack of clarity about that. So you have various accounts. Some people say we want to target caste. Some people say we want to target the caste system. Some people say we want to target caste discrimination. What is caste? I'll challenge anybody here to come up with a kind of coherent, theoretically defensible definition of what caste is. That's a challenge. That's an open challenge. And I also bet that you can't do it. Now, I've got various points here about, so various conceptual categories from Indian culture and traditions are brought in, to sort of equate to the idea of caste, which has always happened. Ever since the Portuguese first said the Indians have casta or castas or whatever, right? The various kind of forms of social organization have been equated to what, to the claim that there is caste in Indian culture. One of the academics who is my opponent, if you like, in the debate on whether or not we should have legislation on this says that caste is a unique feature of Hindu religion. which of course goes back again to the Protestant accounts. But then the Equality and Human Rights Commission, they did a study in 2014, with academics who actually already declared declared themselves in favor of the legislation. So, it was that group which got commissioned to do the report, and they say there's a danger in adopting too precise a definition, or too broad a legal definition of caste, right? So either it should be narrower than contended for, or wider than contended for. We have no real conceptual clarity of what caste should be. I mean that's how I see the quote. That's how I use it. In my arguments. And of course, David Keane, who again features as one of my opponents, who says, well, actually, we don't know what caste is. I'll just leave you with these quotes. These are both, let's say, MPs of Indian origin, right, who made statements in Parliament, right. To me, they are almost like cut-paste accounts of the kind of thing you would have seen James Mill in his History of India, right? He would have come out with these kind of things. Or some other Orientalist, right, from the 19th century. Or a Protestant theologian, right? Like, I don't know, Ward, William Ward, who was a famous Protestant theologian of the time. He would have come out with that kind of stuff. And so we see kind of cut-paste accounts, 200 years down the line in the British Parliament, made by Indian MPs, or MPs of Indian origin. Just leave you a moment to read those. Finito. Grazie mille, thank you.
I didn't mean to abruptly stop you, but it was time to... I think I should move there permanently because you have some slides to show. So thank you for your thought-provoking and I'm sure controversial presentation. And I'm sure we'll have time to discuss those issues more in depth later on, before and after the coffee break. And can you hear me? Yeah, we'll actually now go out of geographical Europe and see a very peculiar, a complicated case, the case of Israel. But maybe I should stop until you move there. Yeah. You do it free? Oh, sorry. Well, like many Asian countries and unlike Europe, Israel has a sort of very fragmented pluralistic situation, personal status systems, where many matters related to marriage and divorce, not all of them, it's very complicated. We pestered him during lunchtime, David and myself, so I guess he's quite tired by now to talk about these details. But anyway, some parts of marriage and divorce are regulated by, are under the exclusive realm of religious authority, some are not. And this fragmented system, very many authors think it's a product of the Ottoman system, which might explain why Lebanon and to some limited extent Greece have a similar system, although Turkey, as we were saying before, has a completely different system. But there are many different theories on why Israel has this peculiar system. Some consider it as a conscious attempt to consolidate Jewish identity, to fragment the other, and to prevent a Palestinian or an Arab identity to be formed in its territories. Somebody consider it as a product of the model or myth of the Austro-Hungarian multinational empire, which inspired, according to many, some part of Zionism in the 30s and 40s. Some consider it as a way to co-opt the religious groups, which were partly not enthusiastic about the idea of Israel. So there are many theories about this, and I think this is by itself a very fascinating issue. Professor Karayanni is going to talk about the issues of the minority personal status system in Israel and how multiculturalism might actually damage religious minorities. He's a professor at law at the Hebrew University of Jerusalem. He's the acting director or director of the Center of the Study of Multiculturalism and Diversity. He's held university posts in many different countries. He's the author of many publications, including recently a text on conflict of laws in Israel and in Palestinian territories. So I'll pass him the floor. Thank you.
Thank you. It's good to be back in Trento from last year. And what I've prepared for today is more of a conceptual kind of a presentation that builds on an article I've just finished writing. And I'll give you some of the basics, some of the information to get our discussion started. But my main argument would deal with the theory of covering. And I would be elaborating further on what is this theory of covering, that we use legal masks to perceive something being, in our case, multicultural, when it is actually not multicultural. It's something else. But we use the legal masks to kind of cover a certain reality to make it look good, when in reality it's very repressive, it's very oppressive. And this is how I would be looking at the millet system in Israel, and it's applicable in a number of other places. Now, to get our discussion started, and this is the second point I would like to put on the table, we're using pluralism, we're using multiculturalism, we're using issues of tolerance, of recognition, but we don't really define what these conceptions are. They convey the idea of acceptance, of letting people live the way they would like to live. But I guess I can give you an example where you would have different legal systems governing different people, but we would not even dare calling these systems as pluralistic or multicultural. And I would flip it and let you see that it might be. Let's take a case that is unrelated to Israel, just to give you a sense of where I'm heading at. Let's go back to the US in the times when there was segregation between the African American, the black community, and the whites. Separate and equal, that was the doctrine under the Equal Protection Clause of the US Constitution. People can be equal, but they should go to separate schools. And yet, if I would be asking this question, as I did to many of my American students, is this something that you would conceive as being multicultural? They would be even offended, right? But still, I mean, it's different schools. People of a different ethnicity would be going to these different schools. Actually, this is what we have in Israel today. Jews and Arabs go to different schools. Religious and secular would go to different schools. Among the ultra-Orthodox community, you would have Sephardic and Ashkenazi schools. They're separate schools. But we would be easily considering these schools as being multicultural. But here, again, in the US context, you would be having different schools for different people of different groups, but you would not dare calling this system as multicultural. But then, let's assume for the sake of discussion that it was the black community calling for different schools in the US. It is the black community that wanted to go to different schools. And that was the cause why you would have different schools for these different communities. Would you now be prepared to call that more multicultural? I guess more in my classroom would say yes. Actually, the Native Americans, the Indians in the US, they would have reservations, they have sovereignty, they have their own school system. Federal government cannot intervene. And this is often an accommodation that is regarded as being an expression of multiculturalism. So what is the essence? We will have group accommodations, people being governed by different systems of laws, and you would call this multicultural, and you would call this discriminatory, racist. But the line is very thin. And what makes things convert from being discriminatory or even racist to multiculturalism in its orientation is a very fine argument. It is not easy. And what I would be trying to point out, what this qualification is. What would turn something from being discriminatory to something that is multicultural when the accommodation itself is just the same? It's on the basis of one's group identity. And this is what I call qualifications of multiculturalism. Now let's begin the journey with some basic facts. In terms of Israel, and some of you have heard me just about 2 months ago presenting at least this issue of my presentation. When religion and state is discussed in Israel, it's very much centered on the issues of the Jewish state and the accommodation of religious institutions. Actually, when you open any book discussing religion and state in Israel, it's very much Jewish-centered. Even the commentary, the basic commentary on constitutional law in its subject index, when I turn to it, looking up religion and state, it would say, see Jewish state. And actually this is peculiar. If you would go to Egypt and you would want to find out issues of religion and state, it would be very much centered on the relationship of the state with Islam. If you would discuss issues of religion and state in Iran or in Saudi Arabia, it would be still centered on the majority religion. Whereas in Western countries, when you discuss issues of religion and state, you would come up with a lot of minority issues. And there is this connection when a state is defined in terms of its majority group, and that majority has a religion, and that religion is part of the state. This religion would be dominating in terms of the discussion on religion and state, and Israel is no exception. But yeah, Israel is very much diverse in terms of its population, right? The overall population of Israel, this is from the latest statistical, governmental statistical book, it's about 8.2 million. The Jews are about 6.2 million. You have about 1.4 million Muslims living in Israel today. The Christians would come to 163,000, and we have a population of the Druze that comes to about 135,000. The difference, if you would add up, you would not get to the 8.2. There is about 300 to 400 local Israeli citizens that are not defined by terms of religious communities, mainly immigrants from the former Soviet Union. But as I said, you'd look at the titles, all of the titles are very much centered on the Jewish communities, even though these titles would be dealing with religion and state in general. Even somebody has written on the topic calling religion and state in Israel the relationship between synagogue and state, which is actually the case. Now, the Christian communities, just to give you a sense, is itself also very much diverse. It is divided among 10 different recognized religious communities, and this is the list of the different Christian communities that exist today in the state of Israel. So all in all, with the exclusion of the majority Jewish religious communities, you have 13 other religious communities that are recognized in the state of Israel. 13 other religious communities. What I mean by recognized is that in each of these communities has now the power to establish its own courts and apply its own laws when it comes to matters of marriage and divorce. There is no civil marriage. There is no territorial law governing marriage and divorce in the state of Israel. It is the religious law of these religious communities governing their constituency, their members when it comes to marriage and divorce. I can go into details in terms of other issues of family law like inheritance, like alimony, like maintenance, like child custody, like adoption, and these would be under the concurrent jurisdictional authority of these religious communities, meaning that there is the need to establish a precondition, mostly it's consent, that the parties would consent to the jurisdiction of this religious community, and by consent, this religious court would now be empowered to adjudicate any of these other matters that belong to family law. So this is what we would call parallel or concurrent jurisdictional authority, and this is not like arbitration, right? The judgment of the court, when it is rendered and it is a religious court, under this concurrent jurisdictional authority is official state court decision. It would go to the execution office automatically, just like any other decision. And so it doesn't need to go into a process of validation of that arbitration award, like in some systems, at least in the case of Israel, would need to go to become officially enforceable. Now, over the time, there has been a lot of very interesting religion and state issues concerning the minority religions in Israel that, as I said before, are excluded from the discussion. And I can give you a number of examples that would offer you some proof of this statement. Like the first case, it's called Milhim, the Sharia judge. It's a case when Israel criminalized polygamy in 1951. Polygamy was criminalized, and a Muslim came to the Israeli Supreme Court saying, this is an infringement on my freedom of conscience, since under Islam I can marry up to 4 wives. And the Supreme Court rejected the petition. It said, well, you might have the privilege of having up to 4 wives under the Sharia, and that's the Israeli Supreme Court. But you're not under a religious injunction to marry up to 4 wives. So if I'm limiting this option, I'm not disturbing a religious injunction. I'm just limiting your options. So this is different. In Jadai, this is the second case. Some of the Christian communities have a hierarchy, an internal hierarchy that exceeds Israel's border. So you would have an appellate court in terms of the Maronite and the Catholics that would sit in Beirut in Lebanon, when the adjudication would be taking place inside of Israel. And so it was a matter of territorial sovereignty. Is Israel willing to accept this jurisdictional authority? And the court said, well, I accept it. This is very religion and state, right? In the US, in these Midwestern states, there has been constitutional amendment saying you cannot even cite the Sharia. You cannot write something in your decision in respect of the Sharia or international law, since these are foreign jurisdictions, even as a citation in your decision. Now imagine this being recognized in the US. You recognized a hierarchy, a court hierarchy that exceeds your national borders. This is very religion and state. Halloun, it was a case among 2 different Palestinian Arab religious communities, the Druze and the Christians. A Christian pub owner wanted to sell alcohol and play what was defined as Western music, which the Druze community thought that it was offensive. And so they petitioned the court to have an injunction, restricting that pub from operating as such. This is very religion and state. And the list can go on and on. The Abu Ghosh Music Festival. A festival was applying for funding from the Israeli Ministry of Education to fund its festival in which Bach music, Saint Johann Passion, was supposed to be conducted, which a lot of Jews would regard as being anti-Semitic. And the Ministry of Education denied that petition. And you had the Supreme Court of Israel discussing this. This is very religion and state. But it's not discussed in religion and state when you discuss religion and state in all of the references I don't want to bother you too much with the details, but I have a thesis that would explain this, and this would lead me to the second part of my presentation. I think when religion and state is discussed in nations that are identified with a certain religion, like Judaism is what I call the official religion of the State of Israel, or Islam, the official religion of Iran. When this happens, religion takes the place of the official state religion. It's in the state's public sphere. It's identified with that state's identity in terms of its self-determination, right? It's public. Like take Israel's law of return, which is the raison d'etre of Israel as a Jewish state. Any Jew can immigrate to Israel by virtue of her or him being a Jew. And you look up the definition of who is a Jew, it is mainly a halachic definition. A person that is born to a Jewish mother or has converted into Judaism and is not a member of another religion. Now, under that law, you can be a second generation Jew or a third generation. You might have your grandfather as a Jew and you would still be able to immigrate under the law, but still that grandfather would need to be considered to be a Jew under the definition of the halakha. And so it's mainly, it's not absolutely, but it's mainly a religious definition. You can take a number of examples of institutions that have been recognized by state law. Like the chief rabbinate, you would have a chief rabbinate, you would have religious councils, you would have laws regulating kosher food, you would have even laws regulating the operation of elevators on the Sabbath, how elevators should be operating on the Sabbath. You would have laws where the rabbis can sit, and all of the rabbis and all of the chief rabbis are state employees. They receive salaries. All in all, I can go on and on, but the argument is that Judaism is not just any other religion in the state of Israel. It is a religion that is dominating Israel's public sphere, and I would regard it to be Israel's official state religion. But when many of these laws are evaluated in terms of liberalism, and here we come to the issue of the freedom from religion, you would find a lot of talk in Israel that there is religious coercion. This is an illiberal kind of an arrangement. It's a necessity maybe for the self-determination, but when you evaluate it by liberalism, a lot of people in Israel would conceive that to be illiberal in terms of its essence. So who is a Jew? The question of who is a Jew, you would find a lot of people saying, who is a Jew? A Jew is a person that feels that she or he is a Jew according to his subjectivity. You should not handle this with the issue of who that person was born to. It's a matter of a personal preference, and if that person wants to be regarded as such, this is how the law should treat that person. When it comes to the jurisdiction of the rabbinical courts, a lot of people would conceive of that jurisdiction to be problematic. So this is Chaim Cohen. He was the deputy chief justice of the Israeli Supreme Court. And when he referred to the jurisdiction of the rabbinical court, he perceived that jurisdiction to be a blot on Israel's democracy. Now, Chaim Cohen was a yeshiva student back in Germany. He became secular, but he was a Kohen. He was a member of a Kohen family, a family in which you had a priest, and he divorced and he remarried, but he remarried a divorced Jewish woman, and that's a problem under the halakha of a Kohen to remarry or to be married to a divorced woman. And it was a big uproar back in the 1960s when he had done that. But nonetheless, he perceives, and this is the dominant perception, that when you evaluate the jurisdiction of the rabbinical courts, you would conceive that as being coercive. This is an infringement on my freedom from religion. You're imposing on me as an individual norms that I, as an individual, do not identify with, and this is religious coercion, as the perception is. But it's a necessity, and that's why you would find people like Zerah Warhaftig, when he is asked to define Israel as a Jewish state, he would mention 2.5 laws that defined Israel as a Jewish state. The first is the law of return that I mentioned earlier, and the second law is the law of rabbinical jurisdiction over marriage and divorce, because that would determine the question of who is a Jew, and that would be determinative in terms of defining Israel as a Jewish state. So it's a necessity we need to have, speaking from the establishment point of view, to maintain Israel as a Jewish state. But when it comes to the jurisdictional authority of the non-Jewish communities, the perception that this is not something that is directly connected to Israel's definition as a Jewish state. Who's a Christian, who's a Muslim, this is not something that is part of the identity of the state of Israel as a Jewish state. So it's not within Israel's public features, it's part of Israel's private sphere. This is your private matter as a minority, and it's not our matter as a state. So there is a kind of a dissonance between the state identity and the religious identities of the minorities. Another peculiar feature is that when this religious authority is evaluated in terms of liberalism, that jurisdictional authority, which is seen to be a blot on Israel's democracy, when it's evaluated in terms of the Jewish community, it is seen to be a sign of the state's democracy when it is evaluated in terms of the religious minorities inside of Israel. And I found a very interesting text published back in 1961, in which the Ministry of Foreign Affairs, the Israeli Ministry of Foreign Affairs, in a propaganda kind of a publication, is speaking very favorably about the existence of the Sharia court and Christian courts in Israel, and even bragging about that the Druze community has been added as an additional religious community that is recognized back in 1957, which the case was. So if you look at the text and you can read through, it is saying exactly what I was saying, that comfortably with the injunctions of their faith, the law vests in the religious communities authorities in matters of personal status. In fact, Muslims and Christian religious courts have jurisdictional powers exceeding those of the rabbinical courts. This is not to condemn Israel, it is to commend Israel. This is the Ministry of Foreign Affairs. And at that time, Egypt was Israel's arch enemy. And look what the ministry is saying about Egypt. In Egypt, for instance, Sharia courts and the courts of other religious communities were abolished in 1956. That's true. But it's not to commend Egypt, it is to condemn Egypt. Whereas Israel is bragging about its recognition. So when it comes to the religious communities of the minorities, the recognition is a sign of tolerance. It's a sign of being plural. It's a sign of multiculturalism. Now, in my class, I usually give my students this exercise. Let's take Iran, for instance. Let's leave Israel out of the discussion. And I would say to my students, let's imagine Iran doing one of two things. Iran is identified with Islam, and Iran is denying Jews and Muslims the opportunity to have their religious courts. Option one, Iran is enabling the Jews and the Christians to have their religious courts. When would you conceive of Iran as more tolerant and more multicultural? When it is denying or when it is recognizing? Most of them would say, no, it is when Iran is recognizing. But this brings me to the second argument. It is the recognition that is perceived to be multicultural and pluralistic, not because of the content of that recognition, it is because of the state's identity. It is me as a state that is identified with one religion. When I would recognize other religions, then I would be perceived as being multicultural and pluralistic. I don't even look at the content of that recognition. And this is the misperception I would like to deal with in terms of covering. What I would be arguing is that this is an illusion. A state can be identified with one religion, and it is denying minorities a right to have their own religious courts and religious law. And that denial is not necessarily illiberal or intolerant. Maybe it's even for the benefit of these minorities that there would be no such recognition. So it's not an intuitive kind of an argument. And this is what I would like to turn now to when I would be discussing multiculturalism as a covering. Because what this is, I perceive this to be covering. You're saying or you're portraying the idea that I'm multicultural, I'm pluralistic, but actually you are not. It's a mechanism of more oppression and more repression of individuals that belong to such communities, and this is the argument I would want to develop. Now, covering as a legal doctrine was developed more in sociology and taken into legal theory by a scholar called Kenji Yoshino, who is a constitutional law professor now at NYU. He previously was at Yale. And he discussed covering in respect of assimilation. Now, the argument is that the US is a country that wants to assimilate people coming from different ethnical backgrounds, religious, and immigrants. And therefore, it is asking these individuals to play down their particular identity and become an American just like all other Americans are. So if I happen to be Greek, if I happen to be Italian, if I happen to be a Jew, I wouldn't be entitled to accommodation in the US. I'm expected to assimilate, to become an American. This is what he would call the assimilation policy. In the US, we are one race, and it is the American race. That's how Justice Scalia has discussed it in terms of affirmative action. And actually, this is why the US Supreme Court today is turning against affirmative action. Not completely, but this is the tendency, is that accommodation is an antithesis to assimilation in the US, and it creates a tension, and therefore the tendency is to deny the accommodation. But if you deny accommodation, it's repressive and oppressive. Because, I mean, assimilation is done in terms of what kind of values? Who would need to give up more in order to assimilate? It is the minority that needs to give up more and to adjust to the standards that are constructed by the majority groups. So the majority group sets the agenda of assimilation according to its own convenient conditions, and we as minorities would need to change more and adjust. So it is repressive in terms of me as an ultra-Orthodox Jew. I would need to give up more in order to adjust than if I was just an ordinary American white person. Assimilation would be done on the terms set by the majority, so that's why assimilation is a kind of covering. In the sense it launders, it makes my repressive reality look as natural. Because it's assimilation, then it is okay. But multiculturalism, the antithesis of assimilation, can just be the same. And this is, I think, the project in many states that are identified with the majority group, with the dominant group. When Iran is giving this millet system or recognizing the millet system, it is repressing what is a common citizenship in that state. When we live in Israel and we are supposed to be boxed within our millets as they are recognized, there would be no one civic identity to which we can assimilate to, just as maybe we can in a Western country. But there would be no one identity that is shared by all of the people coming from the different groups. So when you call it multicultural, you're kind of legitimizing difference and separatism among your class of citizens. And that's why you have a lot of rifts inside of Israel today between people coming from the different millets, from the different religious communities. Actually, there is no Israeli nationality. The Supreme Court was asked to recognize Israeli nationality, as an official nationality, and it says there is no such thing. Now, what makes that possible is that you launder the difference. You would make it look right when it is a mechanism of separatism. You box people within their own identities, and therefore you can explain you're not being able to create a unified citizenship, and you can call that to be multicultural, and that would legitimize this system. Now, I'll finish with this other remark, which I think it's also a minority interest to launder its own discourse vis-a-vis the state by multiculturalism. It's not just a state interest, it's also a minority interest. Now, it has been proven that in a state of conflict, when there is a conflict between groups, these groups would turn inside and become more galvanized in terms of their core identity than they would do otherwise. So if there's a conflict between the Jewish and the Arab community in Israel, and the Arab community is seeking equality, its discourse is very liberal, it's very democratic, it is asking the state to be a state of all its citizens, it is asking to stop discrimination, it is promoting equality and liberal values when it comes before the state institutions. But that minority itself still preserves its patriarchal structure. So you look at the Muslim community, you look at the Christian communities, they're arguing this argument vis-a-vis the state while they want to maintain their religious identity. So how can you reconcile this discourse of liberalism and democracy vis-a-vis the state and holding on to your patriarchal norms within? The way you can reconcile this is by multiculturalism. Once you perceive this accommodation as being multicultural, then you can perceive it as being liberal. You can perceive it as being legitimate, because multiculturalism is itself a project that is considered to be liberal, it is tolerant, it's about recognition. So recognize my particularity as a Muslim, as a Christian, and I would be calling that to be multicultural. But then it would be also reconcilable with my discourse vis-a-vis the state of being or wanting to be equal, wanting to be liberal, and wanting to be democratic. So just to end up, going back to the duck rule, if it looks like a duck, it sounds like a duck, and it walks like a duck, it might not be a duck after all. So when you look at accommodations of minorities in a nation state, if the Jewish community or the Christian community would have recognition in Iran, if the non-Jewish community would have recognition in Israel, this is not multicultural or multicultural necessarily, because you would still need to look at the essence of that jurisdictional authority, and it would need to qualify as such. And to qualify as such, I would mention just two qualifications. One qualification, let's ask the community, is it interested in this accommodation? And going back to the issue of Brown and the American segregation, if you would have asked the black minority in the US, are you interested in being segregated by the whites going to your own schools? Probably they would say, yeah, no. But if they would want their own school system and a majority among the black is moving for it, then this is something that is perceived to be more legitimate. Just like the Native Americans are moving to be in their own reservations. So the first qualifications is, what is that community interested in? Is it its own interest that is motivating the accommodation? Should we be asking that community, is it interested in that accommodation? You mentioned the cultural defense. I wrote an article. What does a culture, how does something qualify as a culture? We speak of honor killing. Is the community interested in this kind of practice? What if only 5% of that community would legitimize committing this violent act against women who had fallen astray or walked astray from the traditions? How does that qualify as a culture when only 5% from among that culture will legitimize it? What about thousands of other cases among that culture where nothing happened to these women who walked astray? Why don't these count for culture and only the very few do? So the first question of qualification is, what is that community interested in? I think the other qualification, do people have the right to exit? Do individuals who are not interested in these norms can have the option of opting out? When this does not exist, you can call it multicultural, but it would not be multicultural because I have nowhere else to go. So the case in Israel in terms of the freedom of religion, if I happen to be a Greek Orthodox, which I happen to be, I cannot go anywhere else. I need to be governed by the Byzantine law of the 14th century, which is the church law in terms of my community, which still speaks of degrading features of society, like if my wife would participate in a party where alcohol is served and it's a race of horses, then this would enable me to divorce her. This is the law. This is very degrading. And I think if I don't have the ability to leave and opt out, you can't call this to be something that represents my culture. So if I don't have the option of exiting, then you can't call it to be multicultural. And the third qualifying factor is that the state should ensure me the right to exit, but it also needs to have a sphere to which I can exit to. So you cannot tell me, well, you can leave your Greek Orthodox community, but the state would not provide a territorial, civil, neutral system of law to which I can exit to and connect to. So exit is not just something I can practice as an individual, but there needs to be a sphere to which I can exit to and become part of, which would not have such norms that I'm running away from. So until such qualifications are provided, you can have accommodations or jurisdictions determined in respect of a person's religious affiliation, but these would not be considered, at least not in my vocabulary, as being multicultural and pluralistic. They would be regarded just a group mechanism which is not multicultural. So to come away from what I've been saying, it's a precaution. It's a cautionary kind of a remark. When you look at the Middle Eastern millet system that exists not only in Israel, but it exists also in Lebanon. I mean, in Israel, you have 14 different religious communities. In Lebanon, you might have 18 recognized religious communities. And in Syria, you would have it. In Jordan, you will. Egypt has a peculiar system close to the Indian system of personal law applied by civil courts. But these are all systems which I think would not qualify as being multicultural. These are group designs. Nobody's asking these communities, are you interested or not? And second, there is no real right of exit of members within that community out of these communities. And third, there is no sphere in the state itself to host people that are exiting and becoming part of something else. If you call that multicultural, it's a covering for this repressive and oppressive reality, and this is what I would like to caution against. Thank you.
Thank you very much, Professor Karayanni. I think a similar issue will be raised by Professor Tsavousoglou talking about this, because in Greece, if I'm not mistaken, Muslim couples in Western Thrace can opt out sort of from their religion before marriage, but not afterwards. And we were talking about it with Prakash. That will come up. I think we have 20 minutes, yes, to have an initial discussion on the first two papers, and then we will have, after the coffee break, two more presentations about the courts under these debates, and then about a very peculiar case of Greece, which is the only EU country which should recognize Islamic law and adjudication by muftis in matters related to family and family law. So maybe we can collect some questions. Okay, go. Okay, maybe, yeah, if I remember, I think the first to raise the hands was you. Yes.
Hi, I am Michel from the University of Torino. I have two questions, one for each speaker. Listening to your last speech concerning the Israeli situation, yes, you gave us a cautionary tale, but at the same time, if I get you correctly, you suggested that if there are these three conditions, it could work, or you wouldn't be opposed to this. Now, this is not exactly the situation we have in Europe. So I would be curious to listen you take a positive stand on the question. Suppose that the three criteria are satisfied. Would you buy the system, or you would still have objections? And the other question I would like to put to Professor Prakash is, and this is linked to my ignorance of the history of India. Okay, let's assume that, and it is, I think it's true, someone mischaracterized the situation in India, and that's where the Europeans arriving. I would be curious to listen, if it is possible, to what would be a more appropriate characterization of the situation in India, from your point of view. Once more, you gave us a sort of negative story, but I would be curious to listen to the positive view of it.
Thank you. I have two, I don't know whether they're comments or questions to Michael, but I'd like to have your opinion on the point that I'm raising. First, you said a system like Israel is not multicultural, and I would agree. But the point is, would that be an example of legal pluralism? And I'm asking you because I wonder to what extent we may say that legal pluralism, as long as it doesn't provide for an exit, as you say, a sort of neutral ground, is by itself just a number of boxes that trap people within their own box, in fact. So that's the first question. Would that be correct to say that legal pluralism is really not flexible enough? Second question, or second remark. I think the situation is even worse than you said, because you said nobody's asking them if they like this situation to have, for instance, their own jurisdiction. This is the case of the various religious minorities. Why do I say that it is even worse? Because it is taken for granted that they agree. So it is even worse because there is no chance of ascertain what is the orientation of the different communities. And I say this because in some cases, and of course I'm talking of a different kind of minority, I'm talking of language minorities. In Italy we have 14 historic language minorities, as they are called. But 3 of them are the main ones. The French-speaking minority on the western border with Switzerland and France, the German-speaking minority here, and the Slovenian-speaking minority on the eastern border of Italy. And the arrangement for bilingualism is completely different in the sense that in the French-speaking area, it is taken for granted that everybody speaks both languages. And so you don't really have to say what language group you belong to. You don't have different classes for French-speaking or Italian-speaking people. Whereas in the case of Slovenian and in the case of German, not only you have to declare the group you belong to, but you have different schools, not only different classes. And in some cases, I'm not sure whether this is still going on, but a short time ago, this was the situation. When the different language groups have to share the same building, the same school, the break is at different times so that they don't interact directly. And the point is, it is the German-speaking minority that wants it this way, because it is an instrument against assimilation, and it is a way to keep their identity. So I would say in this case, it is very different from what I said is your case, and I said it is even worse. Because here it is the minority that chooses what kind of mechanism is preferred in order to protect identity and protect from assimilation, which is regarded as the confusion of the caste. Thank you.
I think maybe we should postpone the other 2 questions by Professor Jamal and by you to after the coffee breaks, that you have time now to answer these complicated questions. No, I didn't mean that.
Well, I said these are qualification factors, but they're not the only qualification factors I would consider. I would think that there would be more. And if you can just look at the amount of writings on exit, which is very instrumental in even having us understand how exit can be difficult at times. I mean, and the example I give of a religious community, I might be a Muslim woman living under the traditions of Islam that happen to be very patriarchal. And when you tell me, well, exit, it's like a zero-sum game. I mean, there are other things in my culture that I would cherish, I would like having, and you're asking me to give up these things as well and to exit, and people would be arguing that this is also inhuman. So even exit itself as a qualification factor can be problematic. I happen to be an ultra-Orthodox woman, and I live under the traditions of the halakha, which are also very much patriarchal. But I like sitting on a Saturday evening or Friday evening and having the Sabbath meal with my family. This is something I cherish. To tell me it's either or, for me it's like, holding the gun in my neck and say, choose between your culture or between your liberty. And this is something that can also be inhuman. So what I've identified here are very basic qualification factors. This would not exhaust all of what I would be thinking of in terms of what the internal norms of that community can be, what kind of internal instructions, female genital mutilation, would I be accepting? Of course not. Even though you would have the right to exit, and you can exit, but there is a threshold that you would not also accept. But what I kind of highlighted here, these are what I would consider to be the very basic qualification factors, which I think are necessary for any group design to be regarded as multicultural. And this is exactly the point. When you have a minority that is asking for the accommodation, it makes the whole difference than from the majority excluding the minority and telling that minority, you be boxed where you are. So I wrote another article, I called it Groups in Context. It depends if you're a minority or a majority that is making the exclusion, and this can flip the whole arrangement on its head in terms of its legitimacy. Now, in terms of the lingual rights, the group accommodations, it's different from the accommodations I've been discussing. In the literature on multiculturalism, we make a basic distinction between what we call external protections and internal restrictions of accommodations. When I recognize a language, it is an accommodation given to the minority vis-a-vis the majority. I recognize French in Canada. It is to safeguard the Francophones from the hegemonic control of the English. But it does not entail a jurisdiction of that minority vis-a-vis its members. And this is the internal restriction that we have in religious accommodations. When I grant the Sharia courts, when I grant the Christian courts, when I grant the rabbinical courts, if you would want to consider that jurisdiction, you are granting that community authority, not just vis-a-vis the majority, but vis-a-vis its members. Its members now would need to come to these institutions and adjudicate their marriage and divorce. So this internal restriction, which is the most problematic, and this internal restriction type of an accommodation, I think would need to meet all of these three qualifications at the very least. But lingual rights, or accommodating minorities in terms of recognizing their language rights, if I would recognize German, if I would recognize French, I'm not telling that community how it should act in terms of its women or its children. I'm just recognizing that language as official. It's something that you can instruct your children with, but it's not kind of instituting the internal restrictions of that community vis-a-vis its members. It's mostly protecting the minority vis-a-vis the majority, so it's not as problematic. You don't need the right to exit. You don't need the other qualifications when you're dealing with external protections. So this is my answer to the two comments.
Prakash?
Yes. I don't think we are really in a position to characterize the social structures that govern Indian society today, because I think there is such a sort of pervasive covering of this framework that I was trying to describe in the study of caste. Also, I mean, you can extend it to the study of Indian religion and so on, right? It's not just about caste. To the extent that I'm not even sure, I mean, apart from very few individual researchers, some of whom I know, nobody is actually seriously raising this question. So the givens, the kind of givens that I was talking about in terms of the taken for granted assumptions which go into studies about caste system and so on, are taken as factual understandings about Indian culture and society today, right? So even if you go to the leading studies of caste, for example, by Nicholas Dirks in California or Susan Bailey in England, you'll find similar types of things infusing their accounts. Yeah, and of course, you can say, well, we can solve the problem by getting a bunch of Indian researchers to do that, but it doesn't work because they are trapped in the same framework, right? What I can say, however, is that if you really talk to Indians who are not infused by this kind of European history of historiography, they don't have any shame about their traditions. They don't come about to you saying that, oh, for me, my belonging to my jati is a shameful thing. It's regarded as a positive dimension of their existence. And that tells you, I think in a way that tells you volumes, because that shame is basically a product of colonialism, and the way in which it's been infused into the mindset of people. And of course, that's now today used as part of a very complex politics of caste, right? So that plays out in the legal and political field intensely in India today, right? To the extent that you see people fighting for reservations in India and burning buses and, all kind of molesting women and all kinds of stuff goes on. With a view to securing reservations. So in India, of course, you have a different politics around reservation system, which is in a way a kind of a more radical manifestation of the kind of affirmative action system that Michel was describing for the United States. So, of course, in India, it plays out in a different way. In the UK, some of the vocabulary and framework is imported now by these same Dalit activist groups. In a way that when you see the responses to the already settled Indian community, or by the already Indian settled communities, they are saying, what the hell is going on? Yeah, this is not part of our experience, right? It doesn't take their experience seriously. Because the British Indian communities to date haven't experienced this kind of politics around caste, right? But because of the politicization of the caste question in India, and the deepening of the colonial paradigm, if you like, in the Indian experience, and the importation of that, this is also having a fracturing effect on social relations in the UK now. Right? So that's quite interesting. So going back to Andrew's kind of insight about the traditions of pluralism in Asian cultures, one thing I would ask is, how is it that such a segmented social system that India represents managed to exist for centuries and centuries? We don't know how far back it goes, right? So we can say centuries or thousands of years, was never problematized by Indian thinkers in the way that the Europeans problematized it, right? Rather than the intervention of the secular state, they found modalities of coexistence, right? And pluralism, which enables members of multiple castes to live around in the same village. Yeah, how do they do that? To engage in certain rituals in which all of them participate, right? How have they managed to do that, yeah? At a village level, right? To the extent that the secular state doesn't manage to inculcate that same kind of mentality today. So there's I mean, your question is interesting, but behind it, actually, it translates into a huge range of questions which are really fascinating, And so one should thank you for asking that question and introducing the topic. But it also carries a lot of research problems with it, right? Or the need to overcome a lot of research problems.
I have the feeling that Michel wants to...
Yeah, just the other comment about legal pluralism and how is it different from multiculturalism. Well, it goes back to my initial point. Is segregation in the US something that you would consider to be legal pluralism? I mean, it says that people of color would need to go to different schools as much as some of these systems that I'm discussing. If you happen to be a Jew, you need to go to the rabbinical court, Christians to the Christian courts. So what does qualify? What makes a reality qualify as something that is legal pluralism? I think there is this thing, when we say liberal, when we say multicultural, when you say pluralistic, these are positive qualities. If I want to condemn somebody, I would tell him, you're an illiberal person, you're an anti-multicultural, you're not a pluralistic person, which by saying this, I'm condemning, meaning that if I'm saying the opposite, then I'm complimenting. So pluralism, like multiculturalism, like liberalism, they have an intrinsic positive value when you ascribe these qualities to a certain reality, generally speaking. So then I would be asking, what qualifies to be pluralistic? I mean, in multiculturalism, we make a distinction between the multicultural circumstance, which is having different people of different creeds and religions and whatever, but this would not make the society to be multicultural. To qualify as being multicultural, you would need to guarantee certain qualities, without which you might end up with group designs that are not multicultural as much as they are not pluralistic. So if I can answer your question about pluralism with a question, I go back, is segregation pluralism? It is a group design, but we obviously think that it is not. Then we need to provide the qualifications, which I think comes down to these basic qualifications that I've mentioned. Is the group interested? Are members within that group that would like to exit are able to exit? Is there another alternative sphere that exists in society that can host these individuals? And that without even going to the basic standards of internal restrictions, which you can add as well. So this is my answer to your question about legal pluralism, which I think it's also a conception that is loaded and it needs to be deconstructed, and we should be asking what qualifies as pluralism or pluralistic.
Thank you. If you agree, now there is a coffee break, and if you don't mind, I would ask you to be back in 15 minutes, because I've calculated that if we want to let Arif, Jamal, and Lorenzo Zucchi to ask the questions for them to answer, then to pass on to the next speakers and have discussion, questions to them, and then a general discussion, we really don't have much time. So if you don't mind, if the organizers agree, I would say 15 minutes.